ये मैटर जो मैं आपको बोलने जा रहा हूँ, आप इस मैटर को हमारे सॉफ्टवेयर पे टाइप करके आप अपनी मिस्टेक्स को जान सकते हैं और अपने शॉर्टहैंड को इम्प्रूव कर सकते हैं, जिसका लिंक मैंने अपने डिस्क्रिप्शन बॉक्स में दे दिया है।
Get ready. Start. The state of Kerala has approached the Supreme Court seeking an interim injunction restraining the Union from implementing the Citizenship Amendment Act 2019 and its recently notified rules. Stop. The center notified the Citizenship Amendment rules to enforce the controversial Citizenship Amendment Act 2019, which is the subject of numerous ongoing litigations. Stop. This is not the first application in this regard. Stop. Several other applications have been filed seeking to stay implementing these rules. Stop. To provide a brief background, the contentious Citizenship Amendment Act 2019 aims to fast-track Indian citizenship for non-Muslim migrants from Pakistan, Bangladesh and Afghanistan who entered India before December 31st, 2014. Stop. This is because of the proviso added to Section 21B of the Citizenship Act by the CAA. Stop. According to this proviso, any person belonging to the Hindu, Sikh, Buddhist, Jain, Parsi or Christian community from Afghanistan, Bangladesh or Pakistan who entered India before December 31st, 2014 without valid documents will not be treated as an illegal migrant. Stop. In 2019, the state had filed an original suit under Article 131 of the Constitution challenging the constitutionality of the CAA. Stop. The state pointed out that in 2019 its assembly had unanimously requested the Union to abrogate this impugned act. Stop. This application reads in accordance with the mandate of Article 256 of the Constitution, the plaintiff state will be compelled to ensure compliance with the impugned Amendment Act and the rules and orders which are manifestly arbitrary, unreasonable, irrational and violative of fundamental rights. Stop. Given that these rules are notified after more than 5 years, the state has contended that the Union has no urgency in implementing them. Stop. Thus, the direction to grant a stay in implementing them is pleaded until the original suit filed by the state challenging the act is decided. Stop. It is further submitted that CAA rules notified much after the enactment of the impugned act nearly more than 5 years indicates that Union of India is aware that there is no urgency in implementing the provisions of the act. Stop. It is submitted that the fact that the defendant itself has no urgency in the implementation of the impugned act itself is a sufficient cause for staying the rules the application state. Stop. Moving forward, the state has also argued that including these three above mentioned countries in the act without any rationale is not only arbitrary but also violates Article 14 of the Constitution. Stop. Bolstering this, it is also stated that while the act covers religious minorities of these three countries, at the same time it overlooks other reportedly persecuted religious minorities or minority sects, including Rohingyas in Myanmar. Stop. The implementation of the rules has also been assailed because it makes religion a criterion for granting citizenship, which is discriminatory, arbitrary and unreasonable. Stop. In this context, it may be noted that over 200 writ petitions challenging the constitutional validity of the act are pending in the Supreme Court. Stop. Additionally, the state has also submitted that the challenged act is manifestly arbitrary and rules are intended to implement the provisions of the act. Stop. Further, it is also argued that this fast-track procedure in the rules is intended to favor only certain groups, resulting in hostile discrimination against the excluded groups. Stop. Get it?